Good morning. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission to consider issuance of, I think it's 2 proposed rules today under the Dodd-Frank Wall Street Reform and Consumer Protection Act. One is with regard to agricultural swaps and commodity options, and secondly, a topic with regard to swap trading relationship documentation, and that documentation related to termination provisions implicated under Title II of the Dodd-Frank Act, which is the resolution provisions under the Federal Deposit Insurance Corporation. Before we hear from staff, I'd like to thank Commissioners Mike Dunn, Jill Summers, Bart Chilton, who I think is on the phone today, and Scott Amalia for all their thoughtful work implementing the Dodd-Frank Act. I think this is our 10th public meeting on these matters. I'd also like to welcome the public and market participants and members of the media today and those listening and on the live webcast. Our next meeting will be January 26th. And we'll schedule additional meetings in February. I think today we'll actually vote on that. On the 26th, we'll be taking up actually 2 rules, one a joint rule with the SEC. I think they're calling it systemic risk reporting, but broadly speaking, it's related to the data collection from hedge funds, and we have a role side by side because we have something called commodity pull operators we'll consider. And I think the agenda for next Wednesday's meeting was actually posted yesterday on our website. The staff's worked very hard on these rulemaking. They'll present the recommendations, and we look forward to receiving public comment. I think on the rules that we're putting out today are, as usual, 60-day comment periods. But with that, I'd like to turn to my fellow commissioners for any opening statements. Commissioner Dunn.
Thank you, Mr. Chairman. I want to thank everyone for joining us today for this important meeting regarding the implementation of the Dodd-Frank Act. Today's meeting will address proposed rules regarding commodity options and agricultural swaps and swap trading relationships documentation relating to the termination provisions implicated under Title II of the Dodd-Frank. The proposed rule regarding agricultural swaps is of particular importance to me. In September, the Commission published an ANPR requesting comments regarding rules governing the trading of swaps in agricultural commodities. The comments received by the Commission were nearly unanimous in their support for treating agricultural swaps under the same regulatory scheme as other categories of swaps, and the rules proposed today do just that. Among other things, I found the comments of the National Council for Farmers Cooperatives particularly helpful and useful. The rules we promulgate must not diminish the ability of farmer cooperatives to provide their products with risk management tools, their producers with risk management tools. I look forward to receiving comments on today's proposed rules so that we can be certain that the ultimate rule regarding swaps in agricultural commodities provides an appropriate framework for those important transactions. The proposed rule regarding documentation relating to termination provisions is also vitally important. The events of 2008 demonstrates that our financial regulatory authorities lacked an orderly mechanism for resolving the insolvencies of certain large financial companies. Congress has sought to address that issue through the Dodd-Frank Act. It is important that swaps be included as part of the orderly liquidation process envisioned by the Act in the event that insolvency of a systemically important swap dealer or major swap participant. Today's proposed rule provides a mechanism for including swaps in this orderly liquidation process. I especially look forward to the public's comment on this proposed rule, particularly in regards to whether there are any unforeseen anti-competitive consequences that may arise from this application, and it's one of the questions that we specifically ask. I would like once again to thank the staff of the CFTC for all their hard work in regard to these very important rules. They have been working late at nights, weekends, in order to implement Dodd-Frank while simultaneously working to fulfill their existing duties under the Commodity Exchange Act. They do this against a backdrop of a budget crisis currently facing the CFTC. We continue to operate under a continuing resolution with funds insufficient, in my opinion, to implement and enforce the Dodd-Frank Act. In essence, we face an unfunded mandate, a situation where the CFTC has been given enormous responsibilities without the corresponding increase in resources necessary to fulfill them. My fear is that the only way to fulfill our duties under the law with our current budget constraints is to become a restrictive regulator rather than a principle-based one. Such a change in our approach to regulations may be detrimental to the current swap industry. Our current staff knows the existing futures industry. In order to adequately understand the swaps industry at the same level, we need more staff and resources. Without adequate staff and resources, my fear is that applicants from entities we are unfamiliar with will take substantially longer than the application from entities we are familiar with. Once again, I would like to thank all of our staff for the hard work they've put in on these rules. Thank you.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. Good morning. I, too, would like to echo my thanks to the staffs of the rulemaking teams today, Don Heitman and his team for agricultural swaps. They've had a couple of different rulemakings with regard to these subjects, and for the second rulemaking, Sarah Josephson and her team, being represented by Ananda and John Lawton today in her absence. But I've thanked Sarah before because she has a big task in the issues that she has under her. So thanks to her team for everything they've done on these rules. On the commodity options and agricultural swaps proposal, I think that the team did a fine job working through the issues that were set out in the advance notice of proposed rulemaking that the Commission voted on last fall. I'm concerned, though, about how we will be handling the agricultural co-ops, an issue that was raised in the comments to the ANPR and by many individuals and entities that have met with commissioners and our staffs over the last few months. In this proposal, the comments are mentioned in the preamble, but the issue is disposed of as being outside the scope of this rule. I have questions on that and whether the issue is being considered by any other rulemaking teams, and intend to clarify that today. On the second proposal, I'd like to thank the team for separately addressing the issue of the termination provision from the documentation proposal relating to the orderly liquidation regime under Title II of Dodd-Frank. I know this was originally in one of last week's proposals, but many of us on the Commission had questions about it and needed more time to consider the aspects of this part of the proposal. So I want to say that as it's presented now, I support it and appreciate the extra week that we had to consider these issues. I look forward to the presentations of the team today. Thanks.
Thank you, Commissioner Summers. Commissioner Chilton, I believe, is on the phone.
Yeah, I'm here, Mr. Chairman. I don't have any opening statement, but thank all the staff for their work on these endeavors, and I look forward to supporting them. Thank you.
Commissioner Malia.
Thank you, Mr. Chairman. Today we're considering our 10th series of proposed rulemakings under the Dodd-Frank Act, and like my fellow commissioners, I'm grateful for the hard work of the staff to produce these. I appreciate Sarah Josephson and her team, and Don Heitman, Ryan Miller, and their team for their work on these rules. Mr. Chairman, Tuesday the President put forward an executive order entitled Improving Regulations and Regulatory Review. Right here in the Wall Street Journal on Tuesday, great story, great editorial about the goals of what we were trying to achieve. I agree with the high standards the President has directed federal agencies to comply with in setting the new rules. I imagine the President proposed these rules specifically to provide some direction to the implementation of the Dodd-Frank Act, including making the staff to improve our process. Unfortunately, the staff informed me that this executive order does not apply to independent commissions like the CFTC. I believe we should make it commission policy to implement this executive order to all of our rulemakings. I'll be asking the teams what steps they've taken to ensure that, at the very least, we're complying with the spirit of the executive order. I hope the Commission will adopt the standards embodied in the executive order entitled Improving Regulation and Regulatory Review as its own policy. With regard to the ag swaps, I'm pleased that we have been put before us a proposed rule that treats ag swaps and commodity options in the same manner it treats all other swaps. With that said, I'm concerned that this rulemaking does not provide sufficient clarity to the question of whether agriculture contracts are eligible for a forward exclusion. Today's proposal declined to answer whether cash contracts based on agriculture commodities are swaps and subject to regulation, or if they are forwards and therefore excluded from regulation. As many commenters asked this Commission to address whether agriculture cooperatives would be exempt from the definition of swap dealer, which my colleagues have raised and I agree with. That in order to fully comment on this issue, I encourage that all commenters submit their comments on the swap dealer rulemaking and potentially the end user rulemaking. With so many overlapping rulemakings, it's understandable that there may be some confusion about how all of these new requirements will work together, but at the very least, it should be clear as to who is subject to the rules and regulations of this Act. With regard to the swap documentation requirements, I have some serious concerns about this proposal, as the proposal seeks to put swap dealers and major swap participants on notice that in the event of a counterparty default, or when there is even the danger of a default, that the ability of parties to exercise certain rights under swap agreements may be stayed under Title II of the Dodd-Frank Act or by the Federal Deposit Insurance Act, FDIA. It may have been the goal of this rulemaking to reduce uncertainty and promote predictability, but unfortunately this rulemaking results in more confusion and more questions in my mind. While neither Title II or FDIA provides a specific role for the CFTC when the FDIC exercises its authority to address defaulting financial entities, we have been asked to use our authority under Title VII regarding swap documentation to prop up the flawed process in Title II and FDIA. If those laws are clear, there would have been no need for the CFTC to put forward under the proposals before us today, which leads me to believe that the FDIC apparently has some concerns regarding its own authority. I would also like to have a better understanding of the CFTC's role in overseeing our registrants under this new FDIC-led resolution process. With the numerous regulations we are required to propose under Dodd-Frank, I don't believe it's in our best interest to adopt unnecessary requirements under the guise of Title VII authorities that clearly exceed the broad authorities Congress decided to provide the FDIC in Title II or FDIA. I believe this rulemaking would benefit from heeding the direction of the President's executive order, specifically Section 2C entitled Public Participation. This paragraph directs agencies to consult with the affected individuals before issuing a notice of proposed rulemaking. This vast new resolution authority could have significant impact on bilateral deals, which I don't believe have been properly considered. In closing, I'd like to recognize the staff for its work, its around-the-clock work to put forward a staggering number of rulemaking proposals, and I'm grateful for their efforts. It is my hope that as the Commission works towards trying to understand the regulations and put them in place by the deadlines included in the Dodd-Frank Act, that we don't put quantity before quality. To that end, let's commit to doing our best to make sure the agency is complying with the spirit and the letter of the laws of the recently amended executive order on rulemaking standards. Thank you.
Thank you, Commissioner Malia. I think with that, I'm going to turn it over to Rick and Don.
Mr. Chairman, Commissioners, thank you. As is customary, I would like to start out by thanking my team. Unfortunately, however, we made an agreement at the outset of this process that they would do all the work and I would take all the credit. So, Section 723C3 of the Dodd-Frank Act provides that swaps in an agricultural commodity are prohibited unless permitted under a rule, regulation, or order adopted pursuant to Section 4C of the Act, the Commission's general exemptive authority. Section 4C includes a few more regulatory bells and whistles than ordinary notice and comment rulemaking, for example, a public interest test. This reflects the fact that, for reasons both historical and practical, the Act has always devoted special attention to the agricultural commodities, Trading in those commodities indeed laid the foundation of modern futures markets. This document includes a lot of pages, but not a lot of issues. The issues really boil down to one primary question, which the Commission raised in the advance notice of proposed rulemaking that Commissioner Dunn mentioned in last September. The question in that rulemaking is, should swaps in agricultural commodities be treated any differently than swaps in any other commodities? With the exception of a couple of academics, the commenters, including general farm organizations, commodity organizations, agribusiness firms, the FIA, ISDA, the CME, the commenters overwhelmingly favored treating ag swaps the same as swaps in other commodities. And I think it was probably put best in a joint letter from a number of agricultural organizations who said, "We urge the Commission to treat swaps for all commodities harmoniously. We believe the comprehensive regulation of swaps should not be based on distinctions among commodity types. The generally applicable protections under the Dodd-Frank Act, such as reporting, mandatory clearing, mandatory trading of standardized swaps, minimum capital requirements, and the CFTC's authority to impose position limits, determine which swaps are subject to clearing and trading, and to exercise emergency powers, will protect ag swaps from fraud and manipulation." Consistent with both the commenters' recommendations and the staff's view of sound public policy, these proposed rules would amend the current rules governing the trading of agricultural swaps to provide that, 1, swaps in agricultural commodities, and 2, all commodity options, including options on both agricultural and non-agricultural commodities, other than options on futures, may transact subject to the same rules as all other swaps. The amendments included in this package would affect the following regulatory sections in order of importance. And Part 35 is the most important, clearly. That's the current ag swaps rules. And current Part 35 is inconsistent with the objectives of Dodd-Frank. For example, current Part 35 prohibits clearing of ag swaps, whereas Dodd-Frank strongly favors clearing of swaps where feasible. The proposed rules would repeal current Part 35 and replace it with a provision that essentially says ag swaps are to be regulated the same as other swaps, proceed directly to the general swaps rules, do not pass go, do not collect $200. Part 32 is the general authority applicable to off-exchange options, including off-exchange options on agricultural commodities. Because all commodity options, other than options on futures, are now defined as swaps under Dodd-Frank, the proposed rules would confirm that all commodity options, again, other than options on futures, will be regulated the same as every other swap. Two provisions of Part 32 deal explicitly with options on agricultural commodities. Section 32.13, which governs agricultural trade options in the enumerated commodities, is for the most part moot and would be repealed since there are no registrants as agricultural trade option merchants. The only provision of Section 32.13 that currently has any effect is the exemptive provision in 32.13G, which requires the buyer to be a commercial and both parties to the ag trade option to have a $10 million net worth. The exemption would effectively be replaced by the less stringent requirement under the general swaps rules that both parties to the ag trade option must be eligible contract participants. Under the Commission's, under the Act's ECP definition, and there are obviously a number of different categories of ECPs, but the one most likely to be used by agricultural interests provides that a commercial entity that is hedging needs only $1 million net worth. So that would make it give a greater number of agricultural interests access to ag trade options. And Rule 3.13, which is the registration provision for Adams, would likewise be repealed as moot. Section 32.4, the other part of 32 that directly addresses agricultural commodities, governs trade options in other physical commodities, including both the non-enumerated agriculturals such as coffee, sugar, and cocoa, as well as other physical commodities such as energy and metals. And 32.4 would also be amended to clarify that such options would be regulated the same as other swaps, thus only ECPs could participate in such transactions. Parts 32.8 and 32.9, dealing with options fraud and misrepresentation, would be retained to apply to swaps that are options. The rest of Part 32 would include this a scope provision in 32.1 and a grandfather provision in 32.10 for pre-existing transactions. Other than those two, the rest of Part 32 would be repealed, and the repeal provisions largely deal with off-exchange retail options, and much of that has been obsolete for quite some time, actually. And then the third section that we're amending is Part 33. Current Part 33 covers both exchange-traded options on futures, which are excluded from the Dodd-Frank swaps definition, and exchange-traded options on physicals, which are swaps under Dodd-Frank and are to be regulated as such. So the amendments to Part 33 would basically remove references to exchange-traded options on physicals from Part 33, making it clear that such transactions are to be regulated like other swaps. So that's an overview. I'd be happy to answer any questions.
With that, I'd entertain a motion to accept the staff recommendation on ag swaps and commodity options.
So move.
Second.
Thank you. First, I just want to thank the whole team, but particularly Don, who was kind enough in the fall when he was thinking about maybe retiring, that he said no, he'd stay and help us to get, I know it's in this several days a week rather than the full time, but that you'd help get us through all of this, and it shows in the work. It's just terrific work. So I wanted to extend my personal thanks to you, Don. I wanted to mention something that came up across all of the commissioner's statements just about agricultural markets. One of the things that occurs is there are many cash and forward contracts or forward arrangements that are entered into in this marketplace that are not regulated, haven't been regulated since the 1930s, nor do we have an intention to regulate the cash and forward markets. We're going to specifically address that in the product definition rule, that the much waited for, but product definition rule. And it has also come to our attention that sometimes people actually enter into forward arrangements for the delivery of milk product, dairy product, other agricultural products through an ISDA agreement, through a derivatives agreement. And we're going to seek to clarify and put out to public comment that even if you're using a derivative contract, if it's still by its nature is a forward delivery, that's not to be regulated as a derivative, and that seems to be consistent with the intent of Congress, but we're still working through all of that. In terms of the issue with regard to farm co-ops, which all of us are pretty familiar with, we really do look forward to the public comment, both to the definition rule that was put out, the swap dealer definition rule, where we had a whole section of questions on that, but I think we'll end up with another set of questions in the product definition rule. And I know that in our private conversations I've expressed, I mean, we really want to get the public comments and get this right to ensure that producers and handlers and merchants, processors all have the abilities to hedge using these products, which I think this rule today helps them along that path. But I agree with the commissioners that we want to get these things aligned in these. I would say there's the three rules. The end user rule, I think, is already proposed and out there. Is very clear that these producer, handlers, merchants are, as Congress intended, exempt, commercial end users. But we'll look forward to the public comments if we somehow didn't get that right. So I just wanted to comment about the comments up here. I don't think I have a question, though, for you, Don. I'm going to just pass it on to Commissioner Dunn.
Thank you, Mr. Chairman. We're going to make an Aggie out of you yet. You've done it.
Trying.
You bring up the importance of the product definition rule, which I think is incumbent upon people that are looking at this rule to look at this not in a vacuum, but holistically. And certainly we try to do that in the commission. The staff tries to do that as we're doing these things of what comes first here. It becomes sometimes very, very cloudy. But it is important to that product definition rule that folks pay attention to that and have their comments in on it so that we can get the right nomenclature that we need. I'd like to take off where Commissioner O'Malley has left off on this review of regulations and how we go about it. And I hate to spring this on our general counsel, but I have talked to him about this in the past. And even though we are exempt from executive order as an independent agencies, there are other specific laws, such as the cost-benefit analysis requirement, Paperwork Reduction Act, regulatory flexibility analysis, that we are required by law specifically to address. Is that not true?
That is correct, Commissioner. We have, under the Commodity Exchange Act and the other statutes you have mentioned, we have specific regulatory and statutory obligations.
And as I read over the executive order, it impressed me that what we do already by law encompasses a large part of that. But then it really is incumbent upon us as independent commissioners at an independent agency to embrace those same issues. And I have, as we've gone on to this process, said many times that I think at some point in time we have got to do an analysis of the efficacy of what we're proposing here, be it 12 months or 18 months down the line.
Yeah, I concur with that, and I would say even further to Commissioner O'Malley's point. I mean, it's only 2 days since the executive order and the opinion piece, so we haven't had an opportunity to get all together on this. I do believe that the spirit of what was there is something that this agency does embrace and should continue to embrace. And one key piece of it is a review of all our rules. Now, we're unique in a sense because Dodd-Frank just passed, but we're going to have a series of what we call conforming rules that look at the whole rule book and say where should there be changes in it because of the Dodd-Frank Act, but also consistent with the spirit of the President's executive order, looking through the whole rule book. Now, in February, hopefully, we'll start on that with regard to intermediaries. So Part 1, Part 3, and Part 4 of our rule book, which largely relates to these intermediaries, we'll do. I've had conversations with the heads of the divisions already and said we need to go through the entire rule book systematically. Today, we're actually, I think, Don told me, I think we're repealing 68 pages of rule text, maybe?
We're repealing About 75% of Part 32, or of Part 35, and 80% plus of Part 32, which works, it's about, if you go with 250 words a page, it's like 40 pages plus.
40 pages. All right.
Well, no, plus another 28 pages of forms that are no longer necessary, like the ag trade option merchant forms. Those are in the rule book.
Now,
too,
I'm sorry I hijacked part of Commissioner Dunn's point, so I'm going to hand back. But obviously, we're adding pages too. So, but I think that the staff is already aware before the President's executive order. But I've told them again, we need to go through the entire rule book, given the new law, and really see what needs to be revised, changed, or, as in circumstance like today, actually repealed.
I'm thinking out loud here, Mr. Chairman, but it might be well for us to keep a running tab somewhere on our website of how many pages we've added and how many we've.
It will definitely be added because we had, a new law that says that we're supposed to add, but yes.
Mr. Chairman, when I served as Undersecretary for Marketing and Regulatory Programs, I had the responsibility of implementing the Regulatory Reduction Act, which required all the agencies to take a look at their regulations and which ones were superfluous and needed to be taken out, which ones had been gone forever. And to your credit, Mr. Chairman, you've had this clean plate initiatives where you've asked the staff to go through to take a look at no action letters, guidance, et cetera, some that had been around for decades, and update those. And what struck me when I was undertaking the Regulatory Reduction Act and what it took for you to do the Clean Plate initiative is that this takes a great deal of time and effort by staff to do that. And I hate to be harping on this all the time, but the lack of sufficient funding is going to have a great deal of an impact on our ability to put out regulations that are that will allow the industry to be as innovative and as quick to act as they have in the past. We have to, I'm afraid, by necessity, move from the principle-based regulatory regime, not only to one that's a prescriptive regime, but as I'm saying now, a restrictive regime. And our ability to do the types of things that I feel were captured in that executive order to a large extent is going to be based upon what human and fiscal resources we have to do that. As you may not know, or you may know, it is incumbent upon the chairman to run the day-to-day operation of the commission. The other four of us simply make policy to make his life miserable. That is it's a tough job to do, and the policies that I think we want to, this particular commission, having worked with all four members for some time now, want to do, I think, are in line with what the President has asked for in that executive order. It's in line with the principle-based regulatory regime. But the reality is we may not have the luxury to be able to do that.
Thanks, Commissioner Dunn. You're getting off, Don, huh? Commissioner Summers.
You really are, because I'm just going to make a comment. I just wanted to say thank you to the chairman for clarifying and confirming that our concerns about both ag co-ops being captured under the definition of a dealer, as well as the contracts being forwards, will be clarified in other rulemakings. So I appreciate confirming that. Thanks.
Thank you, Commissioner Summers, and thank you for working together, because I think we all want to get this one right. Commissioner Chilton.
Thanks, Mr. Chairman. I mean, just to chime in briefly on the reg thing. I mean, it is part of our standard operating procedure to find the the least burdensome path. So I don't think that changes. But the most paramount thing is to make sure, as the chairman talks about a lot, is that we're doing what's in the public interest and what's in consumers' interest. So this is a balancing act we have all the time, and I'm sure we'll continue to strive to reach that balance and do the right thing. I don't have any questions. Really, the staff has done a good job on it and plan to support it. Thank you.
Thank you, Commissioner Chilton. Commissioner Malia.
I just have one question. Before I get to that, let me reiterate my appreciation for your intention to clarify both in the products definition and the swap dealer definition how these products and participants will be treated. It's very important. One question, Don, I have for you is the ECP issue. You touched on it briefly, but I want to make sure that I'm clear on this. For swap, for those who want to trade swaps, there's the ECP requirement.
Right.
And there comes with a kind of a dollar, $10 million or $1 million litmus test to qualify. And I want to ask you if you're confident that that these litmus tests, these requirements, will not prevent small farmers who are not ECPs from continuing to trade OTC swaps and options to hedge their exposure to price volatility.
Well, small farmers can't use agricultural swaps now because they come with a $10 million net worth requirement on both sides. So the proposed rules before you would make it easier for smaller farmers to use swaps, but clearly they wouldn't necessarily apply to everybody. There are some that won't be able to meet the $1 million net worth test, and we specifically have questions in the proposal to basically ask, are there people who would need to use these hedging mechanisms that couldn't, and should we do something differently to address the interests of those smaller producers?
No, I assume the small guys usually go to their co-op. And if we make the co-ops a dealer, then we've made the transaction price on this a lot more expensive, I would assume.
I would assume so. That basically is beyond the scope of our rulemaking, but we got a number of comments from co-ops, from the Dairy Farmers of America, from the National Council of Farmer Co-ops, and we're keenly aware of this problem. We have had probably half a dozen. The Ag Swaps team has had half a dozen meetings with the definitions team, and we have shared our comments that we got that were relevant to their issues. And so I'm confident that they're fully aware of this and that they will address this in their rulemaking. And when we looked at it, even assuming that you could do something in these rules to say that somehow an agricultural swap, when it's offered by a co-op, is some kind of a different instrument and give it some kind of a different treatment, it still wouldn't solve all the co-ops' problems, because they do swaps with their members for propane and diesel fuel and so forth that clearly are not agricultural commodities, and there's nothing we could do about that. So really the appropriate way to address this is through the product definitions and the participant definitions. And we've, as I say, been cooperating with the definitions team and making sure that those issues are addressed.
Can I clarify on the on the ECP definition? So producers, merchants, processors, anyone in the agricultural space, actually it's moving down from just a $10 million limit.
There's from $10 million on both sides to ECP on both sides, and there's a lot of, as you know, a lot of different categories of ECPs.
But so it sort of actually is it's a little bit.
It lowers the bar right now. Yeah.
I see. Okay. With that, Mr. Staywick, if you want to call the roll.
Commissioner O'Malley?
Aye.
Commissioner O'Malley, aye. Commissioner Chilton? Commissioner Chilton?
Aye, Dave, I'm sorry.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
Thank you. With the vote appearing unanimous, we'll be sending it to the Federal Register and also putting it on our website when we send it to the Federal Register, right? Okay. I thank the team for coming back yet for another business conduct standard. I guess we call it a business conduct standard. This is on documentation, and specifically the documentation that swap dealers just include in a provision related to the orderly liquidation of the swap dealer itself, if a swap dealer ends up in being a covered financial institution and has to be, for some reason, liquidated. Ananda, John, the team?
Yeah, thank you, Mr. Chairman. The proposed rule is promulgated under Section 4SI of the CA, which relates to the timely and accurate confirmation, processing, netting, documentation, and valuation of all swaps. And what it seeks to do is to require swap dealers and MSPs to include in their documentation with each of their counterparties a provision that confirms both parties' understanding of how the new orderly liquidation authority under Title II of the Dodd-Frank Act and the current Federal Deposit Insurance Act may affect their portfolios of uncleared over-the-counter bilateral swaps. So as part of this resolution authority, both under Title II and under the FDIA for insured depository institutions, the FDIC is given a 1 business day period in which to transfer swaps and certain other contracts to a solvent third-party financial institution. And for this transfer authority to be effective, a 1-day stay on the ability of the counterparties to terminate, liquidate, or net is necessary. The proposed regulation will ensure that both counterparties, not just the swap dealer, but the other counterparty who may not be a swap dealer, understand that under specified circumstances, if one of the counterparties defaults, the non-defaulting party's positions could be transferred to a new solvent counterparty by the FDIC. Excuse me. And the non-defaulting counterparty or party may not be able to terminate its claims against the defaulting counterparty until 5 p.m. Eastern Time on the business day following the day the FDIC is appointed a receiver. This stay would facilitate the FDIC's orderly liquidation of the defaulting counterparty's swap positions. Staff believe it is critical because it will allow the FDIC the requisite time to transfer the defaulter's open swap positions, claims, and collateral with the objective of avoiding widespread market disruption in the form of fire sales and contagion risk. The proposed regulations would also require that each party in the documentation consent to the transfer of swaps by the FDIC to a performing third party. Now, this provision can only be invoked if one of the parties to the documentation or to the swap is deemed to be a covered financial company under Title II of Dodd-Frank, or is an insured depository institution as defined by the FDIA, and the FDIC is appointed as a receiver. So for our purposes, a swap dealer or MSP that is registered with the Commission could fall under Title II's definition of covered financial company only upon a specific determination by the Secretary of the Treasury after consultation with the President of the United States. The inclusion of this type of provision in the documentation for swap trading relationships used by swap dealers and MSPs could promote legal certainty for market participants and lower litigation risks during times of significant market stress. I must mention that we had very heavy consultations with the FDIC on this particular matter, and we believe that what this proposed rulemaking would do is basically clarify and state what the state of the law is. Thank you.
Thank you, Ananda and team. I'll entertain a motion to accept the recommendation of the staff on this documentation rule.
So move.
Second.
Let me start. I support this proposed rulemaking, and I'll have a statement for the record, but I think what it does is basically just establish through documentation a notice, in essence, that counterparties know that the law, this law, I mean, this is what Congress debated, but this law has a provision in Title II that says that there's some circumstance that swap dealer in a bilateral swap might be in a resolution process with the FDIC. And that swap dealer, if it's in a resolution process with the FDIC, Congress decided, again, Congress made the decision. I happen to think it was a good decision, but nonetheless, Congress made a decision that these things can be resolved, that we Americans will be less subject to the risk of too big to fail, that the FDIC could go in and take over these large institutions. But this rule is not about what Congress did. This rule is just a documentation rule saying all the counterparties need to be on notice that the Dodd-Frank Act did this and the related rules under FDIC. Is that not correct?
That is correct, sir.
Okay. So to me, I think this is a good thing because it puts everybody on notice that if you're dealing with one of these swap dealers, this swap dealer may at some point in time be in this process where upon its liquidation, the liquidation of the swap dealer, you might have to wait one day until the FDIC either transfers the whole book of business or then you can liquidate net out the transaction. Is that correct?
That's correct.
Yeah. So I think it lowers litigation risk. I guess you would say, in a sense, lowers overall risk that in the heart of a crisis as to what happens in the midst of that crisis. And I just remember from my own experience a dozen years ago or so visiting long-term capital management and wondering what would happen to their $1.3 trillion swap book. There was no resolution authority. And the secretary actually asked me when I called him that Sunday night after visiting Greenwich, Connecticut, and he said, well, what would happen? I said, I don't really know, sir. I said, even worse, it's under Cayman Island law. And no one knew at that moment, what the swap book under Cayman Island law would do. So I think what we're doing here is saying, well, it's under U.S. law because Congress passed it, and we're just saying, by the way, U.S. law says there's a one-day stay, and you should know that and be aware of it.
That's right, yeah.
All right, thanks.
Thank you, Mr. Chairman. I think this is, as you watch lawmakers go through and make laws and the Dodd-Frank, it was carried on and on and on, but short of having us set up an insurance package here similar to FDIC or giving us authority to print off $100 bills in the basement, resolution has to take place when this fails. And this, to me, appears a logical way to do it, and providing that notification of the folks who are under our law of what will happen to them. Ananda, how does this orderly liquidation process compare to the liquidation process of other nations?
I'm not sure, and I'll check with the Office of International Affairs. I'm not sure if they have a similar process in the banking laws of other nations. So I'll have to find out and get back to you on that.
One of the things that we have in this proposal is a definition, even though it's not under the definition rule, and that is the determination that swap dealers and major swap participants under the Regulatory Flexibility Act have a designation here similar to what we have with DCMs. And could you elaborate a bit on that?
Talk about the RFA part of the rule? Or?
Yes, and the fact that they are not entities engaged in a de minimis level.
I think, I'll get confirmation from the general counsel, but I think what the advice we got from our general counsel was that, well, previously the commission had determined that large traders are not small entities for RFA purposes, and I think that what the advice we were given is that major swap participants and swap dealers are not considered small entities for the purposes of the Regulatory Flexibility Act. But I'll defer to Dan as to what happens if you are.
Correctly described.
Yeah. Okay. Yeah. So.
Good guess. Ananda, in my opening statement, I stated that I had a fear that without adequate staff and resources, that applications from entities that we are unfamiliar with will perhaps take substantially longer than applicants with entities. Is that an unfounded fear, or do you share that concern?
That is not an unfounded fear, Commissioner Dunn. It's in the context of swap dealers and MSPs, the registration process will be a sort of demonstration of compliance with the regulations. And I think, if we don't, I think what we're proposing to do is to have the NFA do it for us. But what I do fear is that if we don't get the resources, we will have a lot of registrants, the Commission will have a lot of registrants, and we will not know who they are, meaning we will not have any familiarity with these registrants. As I mentioned to you privately, we're going to get registrants, certainly, that DCI will be responsible for that we've never dealt with before. We're familiar with FCMs, we're familiar with DCMs, DCOs, CPOs, IBs, CTAs, because the Commission has been regulating them for a long time. This is the first time we will be regulating swap dealers, major swap participants, RFEDs, so on. SDRs and so on. And they're all. While the concept of a dealer is not new, the concept of a dealer in our space is new. So that is what I'm worried about, that if we don't have the resources, if we're not able to examine them, we will have a whole set of registrants that we have no knowledge about. And I don't think that's satisfactory.
Thank you.
Thank you, Commissioner Dunn. I'm sorry, because I just want to clarify. These are just on the bilateral or non-cleared swaps, is that right?
Correct. It doesn't affect cleared swaps.
Commissioner Sump.
Thank you, Mr. Chairman. In the proposal, there's a provision that says that swaps appear to be subject to the orderly liquidation regime under either Title II or FDIA, since the liquidation regime applies to qualified financial contracts, including swap agreements, securities contracts, commodities contracts, and any other contract determined by the FDIC to be a qualified financial contract. It is also recognized that there could be a potential for regulatory arbitrage if certain swaps are not subject to this regulatory regime. Is the proposal meant to ensure that all swaps are subject to the Commission's jurisdiction under Title VII, that they will meet the definition of qualified financial contract and be subject to this orderly liquidation regime?
I don't think that's the intention of this rulemaking, but that's certainly a question. I think it would be, because the issue is, this only applies if the entity is either a covered financial company, the president and secretary make the determination, or it is what's called an IDI, a bank, for want of a better word. So if that's the case, then I think it would be not a good outcome if only some of their swaps are covered and not all of their swaps are covered. And I think that's what we're trying to get to. I think that if you look at the definition of a qualified financial contract, I think what staff believes is that all of the swaps will be covered.
And how are we going to make sure that all of those swaps are covered?
Well, I think that's the issue for the well, the FDIC has to make that determination, right? Is that correct, Waldo?
Right. I mean, the intent behind this rule isn't to expound upon what should or should not be covered within Title II or within the Federal Deposit Insurance Act. This is merely reflective of what is already in existence there. To the extent that there is any potential for regulatory arbitrage or disconnect between our definition of swap and the definition of swap agreement within the context of Title II and FDIA, that would probably be something that would be better suited for the definitions team.
Yeah.
But we do ask a question in the proposal, or in the preamble, I should say, which says, are there any swaps as defined under Title VII of the Dodd-Frank Act that should not be considered to be qualified financial contracts as that term is defined in Title II and FDIA? Again, trying to get at exactly that question as to whether there is any disconnect between those, the swap agreement definition under Title II and FDIA and the swap definition under Title VII.
Okay, just to confirm, we will continue to work on this issue with other teams and with the FDIC to make sure that there
Yes.
is no regulatory arbitrage
Yes.
there. Okay.
Sure.
One additional question. It is also noted that the inclusion of the termination provision in swap trading relationship documentation could help bring about equivalence in the treatment of swaps globally. Could you explain what is meant by that?
Again, we're not in any way through this rulemaking attempting to expand. I mean, the Commission does not have rule writing authority under Title II. So what we're trying to ensure is that our registrants, the swap dealers and major swap participants, are incorporating within their documentation sufficient notice and agreement to provide the clarity on the front end of the transaction, so that all parties are well aware of the statutory obligations under Title II of Dodd-Frank and under FDIA, so that, again, there is clarity well in advance of, when the problems come up, when there are high levels of market stress, that there isn't a scramble at that period of time. To the extent that the global issue comes up again, the Title II does direct the Comptroller General to examine that issue a bit more fully, and I think that is also something that, as we move forward, will be an issue that the Commission likely will want to continue considering with respect to this rule, and I imagine in a variety of rule contexts.
Thank you very much.
Thank you, Commissioner Summers. Commissioner Chilton?
Thank you, Mr. Chairman. Ananda, you refer, I think it's on page 13, to our role with respect to the potential transferees of QFCs in the event of a default resolution proceeding. How would we handle that? As I understand it now, when an FCM gets into trouble, we work with the Futures Exchange to transfer contracts to a healthy FCM, but I'm wondering how the process might work for swaps, particularly non-cleared swaps, and what are sort of the plans in that regard?
Thanks, Commissioner Chilton. I think, in the current environment for futures, there is an insolvency regime in the bankruptcy that has worked well, and the Commission is authorized to write rules to augment the provisions of the bankruptcy code. And the objective has always been, to the extent that we meaning the industry, can find a clearing firm that's willing to take on the positions and the participants from the firm that's going through bankruptcy, that our role has basically been to clarify what the law is and to appear before the bankruptcy court to support the arguments of the trustee that, you know, the judge should order a movement of positions and a movement of money. And this is, you know, the last time we did this was in 2008 when, you know, commission staff appeared before the bankruptcy judge in the Lehman broker-dealer FCM liquidation. I'll be honest with you, we're dealing with a new world here because in the context of the Title II or FDIA resolution authority, it's basically the FDIC which will be in the driver's seat because the FDIC has resolution authority and we don't. I think, you know, the FDIC, Commissioner Chilton, is required to consult with us for the commission. And I guess I'm just trying to think about what the conversation would be like, and I would imagine that part of the conversation, they may ask us, well, do you know who might be willing to take over these positions? Because I think, you know, assuming that we have advance notice that somebody's going to, you know, be in financial trouble, you know, we can call around and say, well, you know, this person is, you know, this firm is going to, it's common knowledge this firm is going to be in trouble. Are you willing to take over position? That's what the conversation is all about. Of course, we have to make sure that we don't disclose confidential information. So there's a delicate balance there. So I see that as our role. You know, maybe identifying possible white knights, for want of a better word. But I don't know whether our role can be further than that because, as I mentioned before, I mean, the FDIC has the authority, and I think FDIC's got, they got the money. You know, they can create a bridge company and all that kind of stuff. We just don't have that kind of capability. So I know it's not a very satisfactory answer, Commissioner Chilton, but the best I got. So.
All right. Thank you.
Nana, can I just clarify? What staff's recommending and we may propose today is just very narrow.
Oh, yeah, it's very narrow. It is.
Like
it is.
The FDIC has this whole Title II.
Absolutely, yeah.
That's,
they've got their rules.
this is just saying, look, everybody, Title II
This is the law.
and the Federal Deposit Insurance Act says the FDIC might put you on a one-day notice
Right.
or one-day stay. You better know about it and not only know about it, but it's part of the agreements. The swap
Right.
dealers have to,
Right.
yeah.
What we are seeking.
Everything else,
Everything else is the FDIC.
yeah.
What we are seeking to do is to let the whole world know this is the state of the law. It might happen to you, so you better you know either it's we think it's good practice that if it's put in the documentation, everybody will know that that's the state of the law.
Commissioner Maya.
Orderly liquidation is kind of the title of this thing.
Yeah.
I think it's obviously more aspirational since it's never been done, right? We haven't done this. FDIC has no experience in liquidating bilateral contracts. Right?
I'm not sure. I mean,
right?
they have. I'm not sure. I know they have done a lot of liquidation of banks. I'm not sure whether it involves swaps.
Okay. We've got a proposal that puts Title II and FDIA, the Federal Deposit Insurance Act, so into our regulations. You're saying we've got this documentation. This is the state of the world. Mm-hmm. But it is very unclear what the state of that world actually looks like. I think a lot of our swap contracts will say, okay, here's your orderly liquidation. You got 24 hours. You can't do anything with it. But what happens once this bridge corporation or the FDIC gets a hold of it? What's orderly about that? What does that state of the world look like? Can they terminate contracts? They could terminate a swap contract under this authority.
I believe the FDIC does have some measure of repudiation capabilities, and their damage. You know, there's a component I believe there for the award of damages as well. Should the FDIC
so in the 24-hour period, if you're captured and it's totally unclear who these people are, because it simply says covered financial companies, right?
That is correct. That is the statutory.
So,
provision.
what is a covered financial company?
First of all, you got to be a financial company, as defined in the statute.
Right.
So that's, let's see, Section 201A. And essentially, it's a bank holding company, a non-bank financial company supervised by the board. So that, everybody knows what it is. And then number 3 is any company that is predominantly engaged in activities that the Board of Governors has determined are financial in nature or incidental thereto for purposes of Section 4K of the Bank Holding Company Act. And then there's a further provision that says no company shall be determined to be predominantly engaged in activities that the Board of Governors has determined are financial in nature or incidental thereto if the consolidated revenues of such company from such activities constitute less than 85% of the total consolidated revenues of such company.
That seems totally clear to me. So in these swap agreements, will it say, I'm a financial company?
No.
It will not say that?
No, it would not say that.
All right.
So essentially, the FDIC has to say, we believe, has to make a recommendation to the Secretary of the Treasury that in the FDIC's board's view, they believe that company XYZ is a covered financial company. And I'm assuming that, the FDIC will detail why they believe, it is a covered financial company. And then ask the Secretary to take certain steps.
The CFTC is not mentioned in Title II or FDIA, anywhere in that statute, based on what I've seen.
Except for the requirement to, if we're the primary regulator, to consult with us.
Okay.
Yeah.
So what does that, do we have a memorandum of agreement on what that involves? Do we want to have a role in this responsibility? What obligation do we have to our registrants that are captured under this?
I think we would want to find out what the FDIC wants to do. And we want to make sure that there's no disruption in the market. We'd want to know where the FDIC intends to, send the contracts over. But short of that, I'm not. And again, I'd hate to be crass. We don't have the money. So if we want to play a greater role, we don't have the power, nor do we have the money. And Congress has decided that's not our role. So.
Let me go back to the point I was started on earlier. Requiring counterparties in their swap documentation to agree that if a covered financial company defaults, then that non-defaulting party will not exercise any right it has to terminate, liquidate, or net any swap seems to go beyond requiring parties to document their relationship. We've all talked about this is just a simple documentation. But what this actually means, which I hope parties doing these bilateral deals will kind of look at when this regulation comes out or this proposal comes out, what rights they have and do not have under this agreement. Now, obviously, it says here that if they're a party to this, and we've given them some warning, it does say that they can't terminate, liquidate, or net any swap within the 24-hour period. What it doesn't tell you is what happens when you do go into the process and what the FDIC can do to you. Shouldn't we have something in our regs saying, the potential that they could invalidate your contract and terminate these swaps or transfer them, all of these things, shouldn't that also be in this rule? So people clearly understand the state of the world? What is the state of the world? I'm just confused as to what these people should expect going forward by simply including this documentation into their swap agreement.
I mean, in this respect, rather than restating everything that is in Title II and FDIA that could impact a counterparty that's affected here for a particular swap, or in this case, swap agreement. Again, I believe the intent here is to place the parties on notice and specifically address the rights that they would potentially otherwise have within their contract. Again, how Title II and how FDIA could impact those rights under operation of the statute, under Title II and under FDIA. But as far as other elements of Title II or FDIA, hopefully those parties would have an awareness based on this notice that there are, other statutory structures beyond just what we have under Title VII that could impact their rights with respect to this, should a financial company become a covered financial company by virtue of the Secretary of the Treasury in consultation with the President making those determinations.
And potentially, if the FDIC issues regulations, we hope that this provision will give them the notice that, you've got another entity out there that's got statutory powers, so you should be aware that they could issue regulations as well.
I mean, this title is over 20 pages long. It's not, I understand we get you on the hook with with this page and a half rulemaking, but it puts you into a whole new universe here that I'm not sure that everybody's as sophisticated. If a covered financial, if you do a deal with a covered financial, say you're a co-op, and now you have to have this documentation in your rule, small co-op, you should have an understanding of what Title II is going to do to you, right? Or FDIA, right? Because that's your new regulator.
That's I think what it says is that basically it's like caveat emptor or a derivation thereof. You should know who you're dealing with, and you should know that the person you're dealing with, Mr. Co-op, could be a covered financial company under Title II.
Not the co-op. The co-op can't be.
That's right, but
by virtue of having this in their documentation,
sure.
they're in the same process.
It works both ways, because while the assumption is that the dealer is the covered financial company, there may be an instance where the non-dealer, the counterparty who's not the dealer, could be a covered financial company. Though, of course, highly unlikely, but they could be.
Excuse me, if I may just add to the discussion in response to the Commissioner's question, in terms about what rights the parties may have and what the effect of this language is. The language in the rule regarding the parties may not exercise any right that such counterparty that is not the covered party has to terminate is essentially the statutory language. The language of the rule, that in the proposed rule, repeats the statutory language regarding the party will not exercise any right that the party may have.
No, I get that. But what it also presents them is another 20 pages in Title II that they ought to probably be aware of as well, because this is their new state of the world, I guess is your
So
words.
maybe we can look upon it as at least we're giving people notice that a particular law applies, as opposed to they don't have notice and the FDIC comes knocking on the door and says, hey, guess what? I got this power. So
It's probably the least we could do. There's an element in here, this new Romanet 3, down at the very end of the rulemaking, this explicit versus implicit consent. Where in the statutory language is the requirement that the counterparty that is not the covered financial company explicitly consent to any transfer? This language in Romanet 3 inserts the FDIC interpretation of the, quote, or incidental to language in their statutory authority. But that requirement is not in either statute. This seems to go beyond what is in the statute that we just discussed with Mr. Berkovitz.
Yes, Commissioner, as you alluded to in your question, that reflects what we have been, what the FDIC has communicated to us, their interpretation of the provision that we were just discussing with respect to the impact of termination rights within FDIA and within Title II. And within the FDIA context, because again, the FDIC has been operating under that statute for some time now, our understanding from what they've communicated to us is their long-time interpretation of that provision reflects what is in Romanet 3 of the proposed rule. It's not something, again, to understanding, it's not something that is expressly stated in FDIA or in Title II, but the relevant provisions in each of those statutes, which again are substantively parallel, to the extent that it is addressed in FDIA, the FDIC's longstanding interpretation is that this is, one of the results of that language.
Well, I didn't think I was going to quote from the President's executive order today in terms of rulemaking, but this seems appropriate. Before issuing a notice of proposed rulemaking, each agency, where feasible and appropriate, shall seek the views of those who are likely to be affected, including those who are likely to benefit from and those who are potentially subject to such rulemaking. This kind of sounds like we should have put this out as an advance notice of proposed rulemaking to warn companies and participants of this new state of the world and what the new orderly liquidation regime is before we come out with a rulemaking. Because it says specifically before issuing a notice of proposed rulemaking. I think we're getting ahead of ourselves here, and we need to work with the market a little bit to make sure that they clearly understand what's going to happen to them. So that was from Section 2, sub C of the President's executive order. And I think we're getting ahead of ourselves. I'm going to vote no on this.
As I said earlier, I support this. I know there's a difference here, and I appreciate the full discussion of it. I think this is a documentation rule that does, as Ananda said, put people on notice. Congress enacted, yes, 20 pages of Title II, which even if this rule never happened, for some reason we didn't propose it, didn't go final, they're subject to Title II, they're subject to the FDIC Act. I think this helps lower risk in the system, because in the point of crisis, it's right there in the documents. But that's why if there's this support amongst commissioners and why I support it, we'll put it out to public comment, and we'll get comments on all of these, including Romanet 3, and to the President's executive order. I appreciate your point. We have had over 500 meetings, maybe not on Romanet 3, I know, but we have so many people coming into us, and they'll continue to come into us, and we invite that from the public.
I have one more question. May I? I see that we've added a question about the use of swaps and cross-default provisions that reference affiliates, and whether to include these affiliates of entities that may become covered financial companies under Title II or the subject of FDIA in this regulation. Is this proposed requirement anywhere in Title II or FDIA? Ward, I think this might be up your alley. And would the FDIC have the authority to propose this requirement on their own, either under Title II or FDIA?
I think at this point in time, at best, that is unclear. It's unclear. So at this point in time, we thought it prudent to include a question and see what kind of comments we get back, and if need be down the road, address it as appropriate under the statute.
Yeah, that's why we asked the question as opposed to put it in the language, because as Ward said, there is no clarity. In fact, we also asked the question whether the Commission has the legal authority to do such a thing. So I think it'd be very illuminating to get comments on that.
Mr. Staywick.
Commissioner O'Malley?
No.
Commissioner O'Malley, no. Commissioner Chilton?
Yes, Dave, yes.
Commissioner Chilton, aye. Commissioner Summers?
Yes.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 4, the nays are 1.
Thank you, Mr. Staywick. And with that, I have one administrative thing and one technical thing. I'll ask unanimous consent to allow staff to make technical corrections to the documents voted on today prior to sending them to the Federal Register. Not hearing objection, that's taken. And then I needed, oh, that was the administrative thing. So then also we expect to hold 2 open meetings in February, and on the 11th of February and the 24th of February, both of them beginning at 9:30 a.m. here at the CFTC. We'll entertain a motion to publish in the Federal Register a notice consistent with the Government Sunshine Act announcing such open meetings. Do I hear a motion?
So moved.
Second.
All those in favor?
Aye.
Aye. Any opposed? We'll have 2 more meetings. And then I think I just need a motion to adjourn the meeting.
So move.
Second.
All those in favor? Aye. Any opposed? Adjourn the meeting. Thanks.